Yes.
Madam Speaker, the term bail is a common term that is frequently used in our legal jargon, and I presume in other jurisdictions also. However, the term bail remains an undefined term in our law books. It is not even defined under the Bail Act of 1999, which is the main legislation that deals with bail. Even in the Constitution, the term bail is not defined, nor is the term bail used, other than under Section 53A, which has anyway been declared unconstitutional. However, Madam Speaker, the alternative term used in the supreme law of this country is liberty. In the law book Release on Bail, Law and Practice, written by one D.C. Pandey from India, it is mentioned under Chapter 2 thereof, and I quote, "The dictionary meaning of the expression bail denotes a security for appearance of a prisoner for his release. Etymologically, the word is derived from an old French verb, bail, which means to give or to deliver, although another view is that its derivation is from Latin term baiulare, meaning to bear a burden," unquote. Just like we all baiulare the previous government. It goes further on to state, and I quote, that the intent of the arrest being only to compel an appearance in court at the return of the writ. That purpose is equally unanswered whether the sheriff detains his person or takes sufficient security for his appearance, called bail, because the defendant is bailed or delivered to his sureties upon their giving security for his appearance, unquote. Bail is accordingly, Madam Speaker, a conditional liberty, and the right to personal liberty is a fundamental right that is enshrined in our Constitution under Section 5 thereof. Bail thus stands at the crossroads of liberty and security between the presumption of innocence and the imperative of justice. However, Madam Speaker, in lieu of upholding this fundamental right of a citizen to be at liberty, this House will recall that in the not-so-past, the then Commissioner of Police disagreed on many occasions with the advice of the Director of Public Prosecutions not to object to the release on bail of several defendants. This situation even led to the Commissioner of Police lodging a plaint before the Supreme Court. The Commissioner of Police versus the Director of Public Prosecutions, SCR number 124745, for constitutional relief pursuant to Section 83, challenging the powers of the DPP with regards to inter alia bail proceedings at investigation stage. Madam Speaker, since the institution of this new government, this House will certainly agree that this conflict has subsided, but to avoid any such conflict occurring again in the future, this bill is being proposed as to amend the Bail Act with a view to delimiting the respective powers of the DPP and those of the CP with regards to matters pertaining to the release on bail of a defendant or detainee, and with a view to bringing about certainty in this area of the law. Madam Speaker, let me now explain to the House how this uncertainty arose. As per Section 44B of the Bail Act, it provides that where immediately after ordering the release of a defendant or detainee, the magistrate is notified by the DPP that an application to set aside his decision is being made before the Supreme Court and that a stay of execution is required, the magistrate shall stay execution of the order and remand defendant or detainee until the Supreme Court determines the application. In other words, Madam Speaker, only the DPP and not the Commissioner of Police has the power to move for a stay of the decision of the magistrate. However, and most surprisingly, Section 44B of the Bail Act further provides that where a magistrate has ordered the release on bail of a defendant or detainee, both the DPP and the Commissioner of Police have the power to make an application before the Supreme Court to set aside the decision to release the defendant or detainee on bail. These aforementioned provisions are not in consonant with each other, as on the one hand, it is only the DPP who has the power to move for a stay of execution of the decision of a magistrate to release a defendant or detainee on bail, while on the other hand, both the DPP and the Commissioner of Police have the power to make an application to the Supreme Court to set aside a decision of a magistrate to release a defendant or detainee on bail. This is absurd, Madam Speaker. If you do not have the power to move for a stay of execution of the decision of a magistrate, which power is conferred precisely to make an application to the Supreme Court to set aside the decision of the magistrate, how can you, when not having the power to move for a stay of execution of the decision of the magistrate, have the power to make an application to the Supreme Court? In fact, this uncertainty in the law has created this situation of conflict. The more so that two authorities cannot have the same powers. I have perused the Hansard debates of the Bail Bill of 1999, and astonishingly, the Bail Bill which was debated in this Assembly did not contain the provisions that I mentioned earlier. In fact, Madam Speaker, these provisions were introduced at committee stage of that bill. Maybe, I say maybe, when amending the Bail Bill of 1999 at committee stage, a mistake in the drafting of the new provisions may have been made, thus creating that uncertainty in the law. Moreover, the current law grants parallel authority to both Director of Public Prosecutions and the Commissioner of Police to object to bail. The intention was never to create conflict, but to ensure continuity. Therefore, in the absence of the DPP's representative, the police could object to bail based on factual concerns. The DPP, upon reviewing the case and preparing for the hearing, would determine whether the objection was legally justified. If the DPP disagreed, the objection would be withdrawn and the police would abide by this decision. However, recent practice has deviated from this. The then Commissioner of Police has claimed the power to persist in objecting to bail. And even when the DPP, constitutionally entrusted with prosecutorial oversight, considered that there was no legal basis for such opposition. Worse still, the Commissioner of Police engaged the services of lawyers in the private practice to argue cases that the DPP found untenable. This encroachment blurred the lines between investigation and prosecution, two distinct functions assigned by the Constitution to two separate authorities. It led to a toxic situation, one where the police and the apex prosecuting authority were in open conflict, forced into lawsuits against each other, one where public trust in the justice system eroded, as citizens questioned whose orders the police were truly following, one where suspicions of political interference in the detention of citizens became all too justified. With a view to therefore addressing these issues, this bill reinstates the primacy of the DPP in prosecutorial decision-making, ensuring that bail objections are legally sound, free from undue influence, and consistent with the rule of law. Madam Speaker, a magistrate's ruling on bail depends on the objections raised by the prosecution. These objections must be grounded in facts, facts best known to the police, whether an accused has strong family ties that mitigate the risk of evading justice, whether key witnesses remain to be interviewed and need to be protected from interference. These are factual considerations for the police to highlight. As such, Clause 4 of the bill provides that the Commissioner of Police will have the sole discretion not to object to the release on bail of a defendant or detainee before a court. However, where an application is made before a court for the release on bail of a defendant or detainee, and the Commissioner of Police has the intention to object to such release, he shall seek the advice of the Director of Public Prosecutions thereon, and the decision to object or not to object to such release shall rest solely on the DPP. The reasoning to give the DPP that sole discretion is because denying bail is a question of law, one that falls within the competence of the DPP only. Clause 6, Madam Speaker. Clause 6 of the bill further provides that where a magistrate orders the release on bail of a defendant or detainee, the power to apply to the Supreme Court for an order setting aside the determination of the magistrate to release the defendant or detainee on bail shall henceforth rest solely on the DPP in lieu and instead of both the DPP and the Commissioner of Police. In addition, it has been provided in Clause 6 of the bill that where the DPP fails to apply to the Supreme Court for an order setting aside the determination of the magistrate to release a defendant or detainee on bail, not later than 7 days after such an order, the defendant or detainee who had been remanded to custody must on the next day following the expiry of the 7-day period be brought before the court, who shall thereupon release him on bail as originally ordered by the court. Opportunity has also been taken, Madam Speaker, in Clause 3 of the bill to redefine the term detainee, and in Clause 5 of the bill to clarify some bail-related provisions. I wish to inform the House that the office of the DPP and the DPP have been consulted, and he has no objection to the amendments being proposed to the Bail Act. Madam Speaker, I am being tasked, in the absence of my good friend, the Honourable Member, the Attorney General, who is not present, who is unable to come here today, with pronouncing this speech. And I'd like to...
I was actually thinking, I'm sorry, Minister,
yes.
May I just say a word?
Yes.
I was actually thinking maybe it's important for the record that you should say that you are now acting Attorney General, and it is in that capacity that you're making this speech and that you're going to run through the bill. Thank you. Carry on, please.
This is precisely what I was about to say at
yes.
this junction. Yes, this is what I was saying. This is what I was about to say now, and this is why I took note here. I'd said I'm being tasked with having to pronounce this speech today in the National Assembly as acting Attorney General. My good friend, the Honourable Attorney General, cannot attend the National Assembly today, and I have spoken to him just before pronouncing the speech and sought further instructions from him. And I'd like to not only thank him, but also thank all the officers at the Attorney General's office and those who have drafted this bill, who have done an excellent job. And I also thank them for having briefed me in the absence of my, I would say to a senior counsel, my lineage senior, for pronouncing this speech and presenting this bill to the Assembly. So if I may now go on, the bail is not merely a procedural matter, Madam Speaker. It is a constitutional and societal issue. The right to liberty is sacred, but so too is public confidence in our justice system. This bill reaffirms a fundamental principle, that is, the administration of justice must be guided by law, not convenience, and certainly not political influence. The Bail Amendment Bill before the House brings much-needed clarity to a legal framework that in recent times has been clouded by uncertainty and exploited for political ends. Like the recent amendments to the Financial Crimes Commission Act, this bill restores clarity, fairness, and the rule of law. It ensures that decisions on bail are made by those constitutionally entrusted to do so, and that the balance between individual freedom and the pursuit of justice is upheld. With these words, Madam Speaker, I commend this bill to the House.